Before we actually get into the hearing today, I just want to say a few kind of personal words about the licensing subcommittee, if I may, if you will indulge me for a moment, please. The case before us today, as we know, is the Ruby Hotel, and when it was heard for its original license, we had Councillor Williams and Councillor Healy sitting on the case, and we also had Councillor Malcolm Spalding on the case, and very sadly, as many will know in this room, that he passed away recently. And just want to say how missed he is, and what a fantastic contributor he was to the licensing committee and all the subcommittees he sat on. He was always incredibly thorough, very considered, and very fair. And we miss him, and I'm sure everyone in the room will want to acknowledge that as well. So that's just a personal comment. And then also, I want to also say something again, if you will indulge me, about my fellow committee members here today. We have Councillor Pat Healy and Councillor Charles Williams, who have been councillors. Gosh, my maths isn't good enough, but Pat has been a councillor for 24 years. 24 years. And Councillor Williams has been a councillor for 16 years, and sadly they're stepping down next week, and we were going to again completely miss their years of experience. What is that? Over 30 years of 40 years of experience combined. So thank you, and your commitment and your contributions to the licensing committees and all the subcommittees you've sat on has always been incredibly wise, incredibly detailed, and incredibly thorough. And I have learned many, many things from both of you. So thank you very much. Thank you. So now on to today. We have the case before us today is an application for a variation of a premises license for Ruby Hotel, which is 146152 Notting Hill Gate, W11. It's in the Pembridge ward. My name is Councillor Soft McVeigh, and I'll be chairing this hearing, and I'm joined by fellow councillors, if you'd like to introduce yourself.
Good morning, everybody. I'm Councillor Pat Healy. Until next week, I represent Dalgarno ward, which is in the north of the borough. And of the objectors, I should point out that I am acquainted with both Councillor Smetterling and former Councillor and Mayor Joanna Gardner.
Yes, I'm Councillor Charles Williams for Redcliffe Ward, and I also obviously am acquainted with both Councillor Schmetterling and Ms Gardner, but I have obviously not discussed the case with either of them. Okay.
Thank you. Yes, likewise, I know both Councillor Schmetterling and Joanna Gardner. Have not discussed the case with them. I'm aware of the area. I live relatively close, so I'm very familiar with it. I'm not going to go around the room and ask everyone to introduce themselves at this stage, but if you could please introduce yourself before you speak, that would be very helpful. Thank you. The procedure, just for those who are not familiar with it, is on the yellow paper, which should be in front of you now. And the procedure is as follows, that our licensing officers will give a brief outline of the case, and then we'll move straight to the applicant, and they will do their submission for up to 10 minutes. And then each party can question the applicant, and then we move on to the objectors. You're known as the other parties in this, and you will do your submission, and then each party can also question you. And then we will bring in our legal team for any conditions, and then any questions at the end. And we will not do a decision today. There'll be no summing up. We will not announce a decision today, but within 5 working days we will. So, I think we're ready.
Sorry, Chair, if we could just do a formal declarations of interest.
Oh, sorry, formally I have no declarations of interest.
I have no declarations of interest to make.
I have no declarations of interest to make.
And we have quite a few additional papers, which I understand that Mr. Phelan will go through and just check all parties have seen them. Thank you. Mr. Phelan, would you like to start?
Thank you, Chair. Good morning, all. My name is Paul Phelan, and I'm the licensing officer for today's hearing. Today's application has been submitted by Ruby Hospitality UK Limited for the variation of a premises licence at Ruby Hotel 146 to 152 Notting Hill Gate, W11 3QG. The application before you today seeks to amend the wording of Condition 14 to the following. No alcohol shall be consumed in the ground floor bar and restaurant between the hours of midnight and 7 a.m. the following day, 8 a.m. on Sundays and bank holidays, save for persons residing at the hotel. I can confirm that this application did not attract a representation from any of the responsible authorities. The licensing team received 28 valid representations opposing this application. This includes 3 from local residents associations and 1 from a local ward councillor. Copies of each representations are attached to Appendix C, pages 27 to 74. I can also confirm that the licensing team received 1 letter in support of the application. A copy of this letter has been included at Appendix D, page 74. Council records indicate that the premises received no noise complaints over the preceding 24-month period. Council records also indicate that no temporary event notices had been submitted within the preceding 24 months. Additionally, Chair, I just wanted to clarify the additional papers that were circulated yesterday. The first email contained 4 additional documents. The second email contained 8 additional attachments. Effectively, Chair, I can confirm that these were shared with relevant parties and are available in paper format here today. That concludes a summary of the application. I'll leave it there for now. Thank you, Chair.
Thank you very much. Now we're going to move on to the applicant, please. You have up to 10 minutes, please. And if you could please introduce yourselves. Thank you.
Chair, thank you. I'm Craig Bayliss. I'm the solicitor for the applicant. Next to me is Mr. Zhu, who is the operations manager for Ruby Hotels. Chair, can I just first of all associate myself with your remarks about Councillor Spalding? I've appeared in front of the committee many, many times in the past, and I can thoroughly endorse all your comments about his expertise and his helpfulness to both applicants and objectors, so fully endorse those comments. Thank you. It's good to see 2 of the councillors who were on this hearing last time, because hopefully I remember Pat and Councillor Williams' contributions last time. I've had a very helpful discussion this morning already with Heidi, and I think she's probably already told you that we want to make some additional conditions offered, because we are concerned that the residents, with great respect, haven't really understood the very minimal nature of what we're seeking today. So we're trying to offer extra conditions to try and put their minds at rest. So if I can just run through those, it may be Heidi's already spoken to you about them, but if I can just run through them again. The primary purpose for this application is to allow residents of the hotel, no one else, but just residents who are actually sleeping in the hotel, to be able to use the bar after midnight. We already have a 24-hour license to allow those people to drink. It's just a question of where they do it. And what we'd like is to be able to allow a certain number of people who are staying in the hotel to drink in the bar. So the amendments, Chair, are these. There shall be no more than 40 residents permitted in the bar after midnight. We don't actually have permission in the licence currently for any type of regulated entertainment, but you will be aware, and Heidi will advise you, that we could, if we wanted to, play background music. I'm offering a condition which says there shall be no music whatsoever in the bar, not even background music after midnight. Of those 40 residents who might be permitted to stay in the bar after midnight, they shall all be seated. No one shall be standing in the bar. And then a final condition, which actually, Heidi, I should have noted, it's actually probably better noted as an amendment to Condition 27. Condition 27 currently says, all members of the public who are not residents of the hotel shall leave the premises by the end of permitted hours for the sale of alcohol. That's midnight currently. I'm saying that that should now be 2300 hours. So all non-residents, including bona fide guests of residents, shall leave the hotel by 2300. So the effect of that is that after 2300, the only people you will have in the hotel are people who are sleeping there, residents.
Sorry, is that 2300 or 2330?
2300. Heidi, thank you. So, Chair, those are the amendments. I can take this very shortly because it's not in our submission a controversial application in any way, shape or form. We already have 24-hour alcohol for residents in the hotel. The current situation is that after midnight, if I'm a resident and I want to carry on and have another drink after midnight, I've got to go and take it to my room. I've got to go and sit in my room and be a sad old resident just sitting there on my own, and I can't sit down and have a drink in a more convivial space, which might be the bar restaurant area. And so this application is designed to allow up to 40 residents to sit in the bar after midnight and have a drink. No music, no entertainment, nothing else, just have a drink in the bar, just like they could if they were at home. This is not a revenue driver. I'm going to ask Mr. Zhu in a minute to tell you a little bit about it. It is absolutely not a revenue driver. We're not going to make any money out of 40 guests having a few drinks after midnight. It's primarily to allow the facility for guests who want to have a drink simply to do that without being forced to go to their rooms to do it. And there are particular circumstances where it's quite important for example, international guests to be able to do that. They might be coming from America, they might be coming from Canada. They don't arrive at the hotel till 10 or 11. And they don't want to go and sit in their room to have a drink. They want to be able to sit in a more convivial atmosphere and maybe sit down, if they're travelling in company with a companion, to sit in the bar restaurant and have a drink. There are existing protections already in the licence to deal with the concerns of the residents, which primarily seem to be about the possibility of noise breakout from the premises. Well, residents who are sitting in the bar are not going to be leaving the premises. They are already there. We already have condition 30, which says that no music should be played so as to give rise to nuisance. We have condition 31, which says that no independent sound systems will be brought into the premises. So effectively, this is just to allow residents to sit in a bar area and have a drink after midnight if they want to. Let me just ask Mr. Zhu just to address you briefly about the rationale for it, the fact that we do it at our other hotel in Waterloo, and the limited nature of it. Mr. Zhu?
Yes, hi everyone. My name is Ang. I work for Ruby Hotels. Currently, I'm the hotel manager at the Ruby Lucy Hotel in Waterloo, and I will be taking over the operations at Ruby Zoe once we open. The concept of our bar is not for it to be a be at one or bar one. It's simply a additional facility for residents, the guests who pay for the hotel, to be able to enjoy a drink. It will not be a place where the music is playing at all times, loud music. That's absolutely not the case. And also from an operational point of view, we actually do not want to have drunk or disorderly guests after midnight, 11 p.m., whatever it is, simply because our main revenue driver will be coming from the rooms that we sell. And we also have bedrooms on the ground floor in this hotel, by the way. And we value the reviews of our guests. So to that effect, we want all the guests to be happy, and we don't want any complaints or any noise as such. So yes, that's all for me, really.
Do you anticipate this is going to be a big revenue driver for you in terms of making money from the bar?
The bar for our type of hotel, which is a boutique hotel, is definitely not the main revenue driver. We will be lucky if we make any money at all from it. The main revenue driver is coming from the rooms. Yes.
Thank you. Chair, that's it.
Thank you for that, and for that quite significant change. And I just want to bring in our legal advisor here before we continue, but I'm sure there'll be questions about that because it is quite significant. Thank you. Heidi, I think, is just going to talk about hotels in general in the borough. Thank you.
Thank you, Chair. Yes, generally, hotels have always been allowed to sell alcohol 24 hours a day to their residents and bona fide guests. And that is the case in this borough. So anyone can, any resident who has booked a room is entitled to drink 24 hours a day. The difference with this premises is because of the representations which was made when the licence was granted, that where people could sit and drink has been restricted by condition 14. So, as Mr. Bayliss says, they have to bring their drinks back to their room. And here, this application is they want to make a slight amendment so that residents can drink in the bar. And as I understand it, the bar refers to the restaurant, so it's one area, so it's the bar stroke restaurant, and they shall be limited to 40. And Mr. Bayliss has confirmed that he doesn't want to allow any bona fide guests, so they are restricting that further. So I just wanted to make that clear.
Thank you, that's very helpful. If I may, I'm going to start with a couple of questions, probably to Mr. Zhu, if I may. How are you going to monitor who are guests and who are residents? Because you have quite a light touch approach to the check-in, check-out staff, I understand.
Yes, absolutely. So after 11 p.m., the door systems will be locked automatically, meaning that without a key card, you cannot enter through the main doors of the hotel.
Okay, and how does that work in terms of emergency escape?
So if the automatic door system is linked to the fire alarm system, so if the fire alarm is activated, those doors will open automatically.
Okay, thank you. And the guests losing their card, how do they get in? What happens if a guest loses their card and needs to access their hotel?
So there's a speakerphone system by the door where you tap the key card, and then there's a camera on there, so we can see the guest, and then the guest will say, okay, I'm staying in room 217, 220, and then we can check on our system whether the name is correct, and then if that's the case, then we'll let the guest in.
Yeah, but if I can just amplify that, the other point helpfully to make, I think, is that after 11 p.m. you can only buy a drink at the bar if you show your key card. So it's residents only for purchasing drinks, effectively.
Thank you. And just a couple of questions before I go to my fellow committee members. The bar then is going to be staffed. Obviously, it's not going to be an honesty self-service bar. It'll be staffed 24 hours.
Of course, it will be staffed 24 hours. There will be someone, well, at least two, I think, between those hours anyway, depending on the number of emergency exits that we have.
Thank you. I'm going to turn to Councillor Healy.
Thank you, Chair. I'd like to raise a few issues for clarity. You have referred to the bar restaurant area, and it's been repeated by the operator, as being a bar restaurant area. Will there be tables at which people will be taking meals within that bar area? Will there be virtual drinking taking place?
I'm not sure if I understood the question correctly. Are you asking if guests are allowed to have food with their drinks, or is it...
Perhaps I can assist. My understanding is that Mr. Bayliss has offered a condition that in the bar and the restaurant from midnight, that they have to be seated.
That's
So-
right.
So they
Yes,
can't be vertical.
There will be no vertical drinking after midnight.
So I suppose one should just ask, what will happen between 11 and midnight?
You can have the condition from 11 if you want. I'm happy to offer it from 11.
Okay, fine, thanks.
Yeah. Effectively, that's when all the non-residents go. That's when all the guests of residents will go. So from 11 o'clock, we can effectively control that area much more easily because it's residents only. So you can have a condition which says from 2300, all patrons in the bar restaurant shall be seated.
Thank you for that. On similar lines, you said, Mr. Bayliss, that Ruby Hotel is not going to make any money out of 40 people drinking in the bar. Well, I accept that there will be staff there, which is a cost, but surely a hotel charges quite high prices for drinks. How can you not make money out of 40 people?
So when I say we don't make money, we're not doing this as a revenue driver. It's not something which we are doing because it's going to add significantly to the bottom line. It's simply an extra facility for guests. From what Mr. Zhu's been telling me, I mean, we've offered a maximum number of 40 people in that bar, but we don't anticipate we'll get anywhere near that number. It's purely so that residents don't have to go to their rooms and sit in a lonely room watching their TV while they have to have their drink. They can just sit in the bar restaurant area instead if they wish to.
Thank you for that. You also said that there wouldn't be any noise breakout because people would stay in the hotel. What about those who wish to go and smoke?
We dealt with that at the last hearing. If a resident wants to go out and smoke, they're going to go out and smoke anyway. Whether this application is granted or not, if a resident wants to smoke, we don't have any smoking rooms in the hotel, so they're going to have to go outside anyway. We will have a designated smoking area at the front of the hotel, nowhere near any of the residential areas at the rear.
Are you in a position to define what the smoking area will be?
I don't think we can at this stage. The hotel's not going to open until February, March next year, so I think a little bit nearer the time when the hotel's been completed.
If it assists, I think there's a condition on the licence that already says they have to smoke at the front.
Thank you.
And finally, I'd like to have some indication of how you are going to cooperate with and consult residents. They were very angry about the original application, and as you can see, there are many more objections to this application. Are you prepared to meet residents? Are you prepared to have regular meetings with them?
Absolutely. I thought, and correct me if I'm wrong, I thought there was a condition on the licence already which says that we'll hold regular meetings and that we'll provide
There is a condition on the licence.
that we'll provide a telephone number for residents to contact us. But I'm very happy to have quarterly meetings, bi-monthly meetings, whatever the committee thinks is appropriate, because it's important that we get on with our neighbours, obviously.
One final question. Is there a date yet for when the hotel is expected to open?
It's March next year.
Thank you.
March next year.
It's condition 28, the licence one.
Thank you, Councillor Healy. Councillor Williams.
Thank you, Chairman. Yes, just to clarify the point that Mr. Zhu made earlier, the number of staff that will be on duty, from 2300 onwards, there will always be minimum of 2 staff that will be available. If there was, say, a problem in the bar, there will always be at least two people.
That's right, Councillor. A minimum of 2, and then if we have, it really depends on the number of fire exits, because we need enough staff to man all the fire exits. Yeah.
Thank you. Now, Mr. Bailey, you made the point that guests might arrive in the early hours and want to sort of sit down and have a drink before going to the room or something. That's really what you're aiming at. Would you consider the conditions as you have offered them, but with the number reduced from 40 to something like 10, because in this borough there are many small hotels in residential areas where you might get 2 or 3 people having a drink late at night when they've arrived like that. But the larger ones, they tend not to be so close to other residential properties. So I want to explore that and with the...
I understand. I've discussed this with Mr. Zhu. I mean, our original figure was 50.
I know.
We've come down to 40. It's a large hotel. There's 169 bedrooms. So we think 40 is an appropriate number, and it's a number which is proportionate in response to the concerns of the residents. I think to come down from 40 any further is unrealistic in terms of the size of the hotel and the potential number of residents who might want to use the facilities.
The other thing, anticipating something that will be raised by residents, is that they did, one of the objectors circulated some TripAdvisor reviews relating to your Waterloo hotel, which suggested that in this hotel, which is rather smaller, it got pretty lively at night.
Well, as you know, each application on its own merits. It's a different area, it's a different location. I've raised this with Mr. Zhu. Heidi will advise you as to the relevance of discussions about other premises in other areas. But Mr. Zhu tells me that following that review, They then stopped music after midnight, completely. So
Yeah.
the music, they do have regulated entertainment there. They have a DJ there. It's a different type of environment, a different type of entertainment.
I mean, it suggested, and I think the residents will suggest this, is that your brand attracts quite a young clientele,
Yeah.
and there are people who like to party.
Well, I mean, we've tried to address those issues by not having any regulated entertainment, so that's not permitted on the license at all. No music is permitted already. It is purely a hotel that sells alcohol. And again, I've offered extra conditions today, which says that we won't, after 11 o'clock, we won't even have background music in the bar area. It is completely an area for a guest to go and sit down, I emphasise that, and just have a drink.
Thank you.
Thank you very much. I'm just going to ask one more question before we move to other questions about the food offering. Because I remember being in the area such a long time when it was, Damien Hirst's Pharmacy restaurant there, and lots of locals actually want this hotel to actually contribute to the area in a positive way. So I understand we're talking about condition 14 here, but food is a substantial part of it, and on the conditions on the license you have, substantial food must be served at all times. So maybe if you could just elaborate on the food offering here.
At the moment, what we are offering is pizzas and open sandwiches and aperitivo-style Italian daily meats and breads and that kind of F&B offering. That's our current offering, and for the new hotel, we might develop a new, more substantial style. But at the moment, it's, a pizza, I think, is quite substantial in terms of what we offer.
Okay, so on the plan attached to the license on page 17 of the main bundle, so I'm just trying to kind of understand, is there going to be a decent restaurant? I thought there was going to be a good restaurant that local residents, not guests, would actually benefit from.
There is let's not mince words, this is not a sophisticated food offer. It's a restaurant where people can come in, they can have pizza, they can have cold cuts, they can have drinks as they want to, but it's designed primarily for the hotel residents and the hotel guests. It's not, I don't live far away, it's not somewhere I'm going to drive to come and have food. Let's be blunt about it. It's a substantial food offering, but it's not going to be sophisticated anyway.
Understood, thank you. And if, again, a local resident, not guest, wish to go and have a coffee in there and do work on their laptop during the day, and actually, so again, it contributes to the environment, how welcoming will they be, and how feasible is that?
Absolutely, it happens at Waterloo all the time. Yes, there's Wi-Fi's available for people. Go and sit down, have a coffee, sit in the bar area, use your laptop, no problem at all.
Thank you. And I suppose it also, relevant to this particular condition, we're late night food condition. Which number is that? Have we got that?
They don't have late night.
Yeah, should that be looked at now or not?
Well, there's no, the Act provides that you don't need to apply for late night refreshment for hotel guests. There's an exemption in the Act, so you don't need late night refreshment for guests. Food will be available for them if they want it. Member of staff will go out the back and get some pizza for them if they want it, but we don't need to apply for late night refreshment for them because we're only asking for this facility purely for residents, no one else.
Thank you for that clarification. Residents, not guests. Thank you. Sorry. Residents to the hotel, not RBKC residents. Thank you. So now we have a chance now for the objectors to ask questions to the applicant. This is not a chance for you to do your submission, but to ask specific questions on what you've heard already today or from the papers to clarify any questions. I don't know which order you'd like to go in, and if you could please introduce yourself first. Maybe start with Councillor Schmetterling, or seeing you the relevant note. Joanna Gardner.
Thank you. Joanna Gardner, resident and speaking on behalf of Pembrokeshire Association and Bulmer Mews. I would like to go back to the door monitoring because I don't see that somebody's going to be watching everybody. Sorry, my question is, if you've got a key card, what's to stop anybody from bringing other people in with them?
So after 11 p.m., if the guest comes at the door at the bar and order drinks, each individual person ordering needs to show a key card.
Yes, sorry, that didn't answer the question about people bringing other people into the hotel. And secondly, again, only one person usually buys drinks. So again, what's to stop somebody buying around for other people that they brought in? So I don't understand the concept, please. Or could you go and answer, firstly, the door question, and secondly, buying a round of drinks?
So the guests entering the hotel will have a key card. So is your question regarding will they go to the rooms or will they go to the bar?
Well, no, I'm trying to understand how you're controlling the number of people coming into the hotel who are purely residents, because your premise of allowing 40 people to drink at the bar is based on an argument that it is only residents, and you don't seem to be having somebody monitoring the door that only residents come into the hotel.
The staff members who work on nights, they have security training before they join the team, and then they were trained to spot any suspicious known guests that come into the hotel.
So essentially, because you've got two members of staff and they're serving within the hotel, they are checking, they are essentially probably doing their hotel duties rather than checking at the front door. So I think I'm hearing that you don't actually actively monitor who comes in and out of the front door. If you've got a key card, you can come in.
That's correct. If you've got a key card, you can come in. If a guest were to bring other people in and they were to be served alcohol, if this application is granted, we'd be in breach of the condition and therefore subject to prosecution or a licence review.
But I think but you're turning a blind eye potentially to people coming in. I think I've probably gone far enough on this question. If I could just...
I think we all understand where you're getting to, and I suppose it comes down at the end of the day to good management or poor management, and unfortunately that they're not open yet. Okay. So, but please carry on.
So could I ask, the concept of bona fide guests, can that be dropped entirely from the whole licence, condition 15 included?
Now, there's no reason why residents shouldn't have bona fide guests in the hotel up until 11 p.m.
Yeah, sorry, but that's the same as a resident, that's the same as anybody member of the public. Why do we still have to have the concept of bona fide guests at all?
Because it's a standard
but
exemption for hotels. Every hotel in the borough is allowed to have bona fide guests. I mean, you might invite a friend round, they're entitled to do that. I mean, the committee can only do what is proportionate. I mean, this is allowed in every hotel in the borough. And in fact, what the applicants are asking, they are actually restricting their normal ability to serve bona fide guests.
But if that's the case, then I think condition 15 needs to make it very clear that it is only room service for bona fide guests. But you come back to that whole concept of the security aspect on the front door. How do you differentiate between a bona fide guest and a member of the public that I happen to bring in because I met them in the pub and they said, come back to my hotel and we can drink further? I'm struggling to understand, and I'm happy if the applicant could clarify the difference between a bona fide guest and a member of the public.
I think you're going around in circles here. I think they have answered to the best of their ability, and we as a committee will have to decide whether we believe they'll be able to manage that with their members of staff on duty and their key cards. But I understand where you're coming from. Thank you.
Thank you. And just one more question.
Sorry, can I just clarify? Under the licence, and this is not a review, they're specifically entitled to have residents and bona fide guests there 24 hours. And
I, in my objection, have queried that. I'll raise it in the speech because I don't believe 14 and 15 can now work together.
No, I understand that, but this is not a review. So we can't take away what they've already had.
Yeah, I'll talk about it in my speech. Yeah. Thank you. Could I just
sorry, I've just got to really make that clear as chair of this committee. This has been advertised as changes to condition 14.
And I
this
agree.
Is all we are within our remit
that,
to look at.
But I therefore think if you're going to alter 14, you have to look at 15 because of the implication and the knock-on effect. But I'll address that in my speech. Thank you. Could I just ask about smoking? So, how is the applicant planning to enforce, if he's only got a minimum of 2 members of staff on the door, how are they going to look to enforce that nobody is smoking around the back? And also, we all know that, I'll leave it there, thank you.
Conditions 25 and 26 require us to ensure that no one smokes at the rear of the premises and that anyone who is smoking does so at the front. There is CCTV at the front of the premises and also at the rear in the service yard, which will be monitored at all times.
Could I have an answer from Mr. Liu, please? Mr. Ju, excuse me. On a practical basis, please.
There's no exit doors on plans right now to the back. There's only the main exit from the front at the moment. And to go at the back, if I remember correctly, you actually have to walk and then turn left through a quite narrow lane. And I don't see how the guests would want to do that, first of all. And second, as Craig said, we have CCTV cameras that we can monitor 24/7.
And how will you monitor that people don't go out with glasses as well? I'm just very conscious that these 2 members of staff seem to be having to watch keycard monitors, serve people drinks, and also watch the CCTV cameras as well, all at the same time.
There will be a CCTV iPad placed behind the reception. There's always someone behind the reception monitoring that. And then the other staff member working there is checking as well. So it's, yeah.
Okay. And just one final question on the food. So there is now no longer any dedicated restaurant. Does that mean the whole floor can be used for snacks, for breakfast snacks, or is there now any dedicated restaurant area for breakfast or for any other meal?
The whole concept of the hotel lobby and bar and the restaurant area is all in one. So we don't even have dedicated check-in desks. So the idea is a living room for our guests. So if they want to do work, they can do work. If they want to drink, they can drink. If they want to eat, they can eat. We don't have one area specifically saying you have to sit here to eat, you have to sit here to work, and then you have to sit over there to drink.
Thank you.
Thank you for your questions. Any other questions from objectors?
Yes, my name is David Graham. I'm representing the Residents Association and Mrs. Lombard in particular. Just to follow on from the last set of questions, can I understand that your evidence is that you've got 2 members of staff, and they are, one of them is at all times, you said, behind the reception desk watching CCTV. Mr. Zhao, is that right? There's one person sitting behind the desk at all times. Okay. And then there's going to be 1 member of staff serving behind the bar?
The bar and the check-in kiosks are together. So you'll have one long bar, and one side of it is check-in iPads, 3 or 4, which is linked directly to the bar. There's no dedicated, so they're not separate. It's all in one.
So, sorry, did you say the bar is the check-in desk, effectively, because there are iPads on the bar, or what? How does it work?
There will be an iPad there somewhere. I don't know where it will be exactly because it hasn't been built yet. But there will be a storage space, I don't know, on top of the bar, below the bar, under the bar, where it can be seen.
Okay, so what you're saying is those 2 members of staff then are going to have to monitor who's coming in, and also monitor the issue of people at the back of the premises.
We're not restricted to 2 members of staff. There may be more members of staff, depending on how busy the hotel is at any one time. Mr. Zhu will have a total complement of, I think, 22 staff. So it's for... Let's remember that we are still nearly 12 months away from opening these premises. So staffing levels, management teams are all still to be decided. And I think we're talking in very abstract terms at the moment here about issues which aren't really germane to the application.
The question for Mr. Zawi's, which I could be grateful if you could let him have the opportunity to answer, is you haven't presented any assessment of these issues and a staffing plan, have you, to the committee? Now, in respect of the question around the monitoring of the doors, are you prepared to offer a condition in relation to the exits? Because at the moment you've said that the intention is that there won't be an exit to the rear yard area. There is an exit.
There will be a fire exit.
I beg your pardon?
There will be a fire exit.
Yes, there is a fire exit shown on the plan. Are you prepared to agree a condition that the exit to the rear of the hotel is only to be used for an emergency evacuation?
While you're formulating another question, if I could just jump in here about what you just touched on there about 22 members of staff and what Mr. Graham mentioned about a plan, because I know this existing licence is very thorough. There are 31 conditions. Increasingly now, before this committee, we find that we often add a condition about a management plan to be submitted to the licensing authority before operation and before opening. And I know, again, you're 12 months away from this, but would that be something that would...
Absolutely, Chair. I'd be very happy to accept it. I don't know, Heidi, if you've got a standard wording for it, but and I don't know what you'd expect the management plan to cover, but it will certainly cover things like staffing levels at particular times. So 22 staff, obviously a busy Saturday lunchtime, you're probably going to have 22 staff on. 2 o'clock in the morning on a wet Monday evening in January, probably going to only have 2 staff on. It's going to vary from time to time, obviously, in terms of the busyness of the hotel. But I'm very happy to accept the management plan condition if you've got one.
We do have a standard condition. I don't have it with me at the moment.
And I think, again, if I may, again, you know, we are loath at this committee to tell any business how to run their business, but when it comes to the serving of alcohol, obviously, we have the licensing objectives we have to consider. And I just feel the communications between residents and yourselves would benefit from a bit more of dialogue. And again, I understand you're 12 months away, so you're not sure who the team will be, but if we could make that a bit of your priority, I think would ease matters, irrespective of the committee's decision today.
Mr. Zhu's already said to me that he'd like to speak to the residents after the hearing today to establish some connections.
Residents, did you hear that? Yes, thank you. Sorry, Mr. Graham, would you like to continue with your questions?
Thank you. So the other aspect that residents have got concern with is around the what I call light pollution from the premises. You haven't addressed that in your application, have you?
No.
Is it your intention, Mr. Zhao, that there will be internal illumination of the bar area?
Yes.
So that is a concern for residents, and it simply hasn't been addressed, has it?
No.
Now there's another question here, which is about monitoring the outside smoking area. If it's illuminated inside, it must be right, mustn't it, that you can't then see outside because you just see the reflection of the inside if you're sitting in the bar area.
I'm just going to jump in here. I know you find this frustrating, but this is really important that we have to go through all these things. And light pollution is an issue that we also looked at as well. Again, I don't want to stray into the planning committee's authority, but perhaps it would be something that blackout blinds or something on the back row of those windows could be considered after a certain hour. I know that alleyway very well. I actually personally think the glass front on that alleyway will actually help with antisocial behaviour, because the more visibility you have in areas will stop people, urinating or doing drug deals or nefarious activities there. But I can understand the Victoria Gardens residents, the expanse of the glass at the back into your homes. I can completely understand that.
Chair, I am concerned that we are straying into planning issues rather than licensing issues here. Whether or not this application is granted, there is currently nothing to stop the premises leaving the restaurant bar area illuminated currently throughout the night. There's no condition on the licence to stop that happening now. Why this should suddenly be raised at this juncture in relation to this application in my submission is irrelevant, because we can do it already.
I would caution that this is not a planning application, although someone did submit the planning permission as an additional paper, which you have, and there are a number of conditions attached to that document. And normally light pollution is something that would be covered by planning. I can't see any condition jumping out at me at the moment, but it's not something that licensing would normally cover in light pollution. But I do think we have to be careful about straying into issues which are really matters for planning as opposed to licensing, because the guidance is quite clear that we mustn't duplicate that regime.
So everyone is clear on that. I suppose the reason it has come up is because the bar will be, if we were minded to grant guests sitting in a lighted bar all night, then that will affect residents, and you could potentially call it public nuisance if we were to go that far.
Chair, I think the best answer I can give to the committee is Mr. Zhu hears what you say, and we'll take that back to his superiors in terms of how we manage the interior going forward, because we are still nearly 12 months away. But it's certainly something that we can look at in terms of the potential for light pollution.
I can answer that.
Thank you for that.
Oh,
That'll
Mr.
be noted.
Mr. Zhu's happy to give you some confidence about that now, apparently.
So we have 4 different light settings, one for the morning, one for the midday, one for the evening, and one for the night. And the night one specifically is so dim that we use candles to light up the tables at our Waterloo Hotel right now. So personally, I don't believe it will be a problem. However, I'm very, very happy to talk to residents that want to bring up this issue with me. It's no problem at all.
Thank you. I do think having these things aired in public really does help, because people, Sorry, would you like to continue your questions?
Sorry, Councillor, unless my client, I'll ask for a minute to go further with my client. I think that those are the questions I had, but I would like to just lay down a marker now, as it were, and of course I can address it if it assists in my time. We don't accept that lighting is a planning matter and not a licensing matter. It's clearly got the potential to cause a nuisance to the residents of Victoria Gardens, but I'll address it in my own time, as it were. We don't accept there's any impediment whatsoever to this committee imposing a condition in relation to lighting, whether it's for blackout or anything else. And in particular, the reason that we requested the planning permission be included is because you have to have regard to that under the guidance and the authority's own planning statement of policy, licensing statement of policy, because they encourage you not to duplicate controls and to integrate the controls. And the point that we would like to make
Chair,
here
is this a submission or is it
well,
questions?
it is a submission. I can do it in my own time.
Let's do it in your own time. Thank you.
you.
Fellow question?
Yes, I have a question. A Victoria Gardens resident, Sebastian Pearson. Yeah, it's regarding the light pollution at night, and the 24-hour license, as you suggest, would mean light into Victoria Gardens all night long. And so the idea of blackout blinds to stop any illumination going into Victoria Gardens would be very welcome, because it doesn't matter how low the lighting is, it will still illuminate what is a night sky outside. So it's a very quiet residential neighbourhood, and that lighting will affect all of us residents.
Question.
It is. Sorry, could I just ask one point about smoking? I know Mr. Bayliss talked earlier about the fact that you can't stop people smoking and that it's already there. I think one of the concerns that the residents have is that actually with increased drinking, and if you're on the ground floor, there's more chance that you will be going outside smoking. And so the question is, would the applicant look at controlling the number of people that actually go outside to smoke at any one time? I know this committee put something similar on at the Act recently, but it's that external noise, whether it's at the front or the back, and there are residents in Notting Hill Gate opposite the site.
Yep.
No more than 2 persons outside smoking after 2300.
Thank you for that. Councillor Smettling, question.
Thank you. I've just got one question at this point. Could Mr. Bayliss please explain why he thinks the residents didn't understand the request, which he said right at the beginning?
I understand the question, Councillor Schmidt.
You said the residents did not understand what you're requesting in this application for a variation.
Is that a question I need to answer, Chair? I'm sorry,
That's up to you.
I don't understand.
Perhaps if you'd like to kind of clarify that comment you made.
In my opinion, the application was clear in what it sought to achieve.
Okay.
Sorry, may I ask, just follow up, Mayor? Mr. Bayliss, you clearly said that the residents did not understand what you're applying for, and I'd like you to explain why you said that, please. The question is, why did you say that?
I'm happy to withdraw the comment if Councillor Schmetterling finds it offensive.
Thank you for that. Understood. Thank you. And also, I do want to just clarify that actually the applicant has made significant changes. So when we get on to doing your submission, please, if you could relate that to what you have heard today from the applicant about 40 residents, guests, sorry, what are we going to say? Hotel patrons, thank you. Hotel patrons in the bar after midnight, no regulated music, no background music after midnight, and all seated after midnight, and now during the course of this discussion he's said all seated to 2300. So before we get on to your submissions, and also any non-patrons to leave by 2300, not even 2330. So if you could please address your submissions to what you have heard today, not probably what you've prepared, if that's okay. Thank you.
Thank you. Joanna Gardner speaking on behalf of Bulmer Mews Residents Association and Pembridge Association. We live at the rear of the hotel and are very concerned about the negative consequences of granting this amendment will have on the true residents of the area, those in Victoria Gardens, Ivy Lodge, Gate Hill Court right next to it, Bulmer Mews, and of course Notting Hill Gate itself just opposite the site, rather than those who merely come to stay or visit the hotel. We wish to focus on 2 aspects, Condition 14 and its expansion to include the entire ground floor as a bar, 24/7, and Condition 15, which allows bona fide guests of hotel residents to drink beyond midnight, and how this is intended to work with Condition 14. As you'll see from the original plans, on page 33 of the pack, there was a purple area designated as the restaurant and bar to the right, and with retail to the left in yellow. It is this purple area which the applicant is now seeking to remove entirely as a restaurant and convert the yellow and purple area into a 24/7 bar. Matthew Ballon, the Ruby Hotel designer, has said to us that the Ruby Hotel has no reception nor a restaurant, merely a bar to meet and greet visitors. The hotel walls are glass, double height, 10 foot tall, And so whatever goes on in the hotel is highly likely to impact the surrounding areas and residential neighbours. Glass to the side, glass to the rear and glass frontage, with noise and light nuisance a major concern for neighbours. At the rear of the houses at the hotel is Victoria Garden houses, which are literally only 20 metres away. And the glass does not have the acoustic properties to block out noise in the way soundproofing can. And we all know, I myself was kept awake by a neighbour who had an all-night party the other day, that noise doesn't block out shouting or singing from voices. When we stood up and spoke at the first hearing to grant this licence, we felt reassured that the major drinking would cease at 11 p.m, as the bar and restaurant would cease then, and this was reflected in condition 14. An off licence was required to allow staff to provide drinks to hotel residents and their, quote, bona fide guests outside of this. And as Mr. Bayliss stated, and as recorded in the decision of the Licensing Committee in paragraph 14, we expected this to be room service and inconsequential as a small supplementary offer to hotel guests. To find ourselves faced with the hotel now seeking to create a destination 24/7 bar for guests and do away with the internal controls on drinking and the hours is to erode local residents' lives yet further. With nighttime and early morning drinking comes smoking outdoors and noise. As I said above, glass is not a great sound limiter, and voices carry outdoors and indeed indoors. And the later into the night, the more impact this has on neighbours as the background noise lessens. Even a limit of 40 guests is significant. We've all been to parties or events where people are chatting and talking, and everybody starts talking louder than everybody else, and it will have a significant impact on neighbours in causing a nuisance. I am even more surprised that the applicant offers no additional conditions for a 24/7 bar, no additional door security to ensure only hotel residents come in, no measures to protect children staying at the hotel, no means of checking drinkers, no control over external smokers, sorry, we have had that change, and no apparent offer of staff to police existing conditions, e.g. no smoking at the rear. It all comes across as very lax, and a hotel focusing on its offering as opposed to being a good neighbour, given how close we all live and how the area becomes quiet at night. Today, the Licensing Committee is faced with a decision whether or not to allow a 24-hour bar 7 days a week in the area. There's nothing in the area to match that, and rightly so, because residents live alongside businesses. The applicant hasn't made his case as to why the ground floor should become an entire bar, as is set down by the committee's own rules, as to why it should operate so late, and nor has it offered any additional measures to seek or to allay residents' justifiable concerns. My last point is that notwithstanding our opposition to the change sought to condition 14, we fail to understand how this would then work with the existing condition 15, which allows hotel residents and their bona fide guests to drink via the on and off licence provision 24 hours a day. The hotel offers no conditions to manage and controls who drinks in the bar, who is a resident or a bona fide guest. And again, this seems a cavalier approach to enforcement by the hotel. There's nothing proposed to stop the hotel from serving residents in the bar under the amended condition 14 and serving bona fide guests via the off-licence provision 24 hours a day. I really do not understand how you can allow residents of the hotel, patrons, to drink in the bar, and yet they could still have a bona fide guest elsewhere in the property, so that they can then run off with their drink. And I do not understand how the concept of bona fide guests is now allowed to sit if you do amend condition 14. It should be deleted entirely to avoid a backdoor route and confusion. If not acceptable, then measures should be introduced to make it very clear that only bona fide guests have to sign in a ledger on their arrival, and that a bona fide guests can only drink in room service. So you delete the word may in condition 15 and replace it with shall. So in essence, we strongly object to this variation, believe it should be refused in its entirety, because frankly, more people sitting downstairs drinking and smoking later into the night will inevitably lead to people going outside and being noisy, as well as raised voices inside, which is so close to the residents next door, opposite and behind. Thank you.
Thank you very much for that. I think before we ask questions to you, we're going to hear from the other objectors, and then we'll ask questions as a group, if that's okay. So who is going next? Thank you, and please introduce yourself. Thank you.
Good morning. My name is Howard Malin, and I live in Ladbroke Walk, which is perhaps 50 yards from the subject site. And I'm here representing myself, but more importantly, my mother, who is 96, and who lives in Gatehill Court on the 4th floor. She is fortunate because she's possibly 16 feet from the rear window. And there's been a lot of talk today about residents, but these residents include the occupiers of the ground and first floor at Gatehill Court, who all have a bedroom at the rear of the premises, which can be 3 to 4 feet away. I don't think we're here today for you to review whether or not the public nuisance, safety or amenities of the residents will be affected. It's to what extent, to what degree, and for how long they will be impacted. To a certain extent, I was gratified when Mr. Bayliss told us that the restaurant would not be a place that he would visit. Not that we would wish not to see him in the area, but because I think what his point he made is that the food offering in the hotel, and Mr. Zhu can correct me if I'm wrong, is there simply to satisfy the conditions of the license. If that is the case, and the restaurant is not to be a main driver of the premises, then perhaps there will be less rubbish and less refuse to be collected, which will disturb the residents less. However, the proposed 24/7 application to vary will have an impact on the residents and the areas. And I speak from the experience, not that the committee do not have experience, but I'm a former license holder myself, a multiple license holder, having had restaurants, hotels, bars and clubs, both in the borough and elsewhere. And there is, as we know, a relationship between drinking, between alcohol and behaviour. So, yes, of course, there will be an increase in public nuisance, and yes, of course, there will be an increase in the disturbance caused to the residents. It's by how much and for how long. And I cannot see how the committee would consider favourably an application to have drinking beyond midnight for residents, for their guests or otherwise. I thank the applicants for the concessions they've made today, which go to endorse my point by degree. They have reduced by some degrees because they acknowledge it would cause, that acknowledges that it would cause disruption and inconvenience and loss of amenity to the residents. And with all due respect to Ruby Hotels, we're not in Shoreditch and we're not in Waterloo, but we're in Notting Hill, which is certainly behind the hotel is a very quiet residential area. And since your profit will not be affected, I cannot see any resident arriving, any guest of your hotel arriving after midnight that will be put off staying in the hotel or returning to the hotel because they were not allowed to drink in the bar. As you said, these might be solo travellers who don't want to drink alone in their room. They want to socialise, and we know what that leads to. Sorry? I think that's probably what I have to say, except that I can see that the various applications show how the license is stealthily creeping to allow longer hours and perhaps different conditions. And so I would urge the committee to consider very seriously the impact on the residents of Gatehill Court.
Thank you for your submission. Thank you very much. Other residents?
Madam, if I may go next. So, our objections to this fall into under the head mainly of disturbance to residents. I've raised the issue earlier, and Mrs. Gardner has as well, about light pollution, but that is a very serious concern. One only has to go and stand outside at the back of the yard where they're constructing the hotel, as I did this morning, to see that there is an immense double height frontage of glass which not only faces Victoria Gardens, but it wraps right around the alleyway as well, and the front of the hotel. And the effect of that is twofold. First of all, it will mean that the bar, the existence of the bar, the fact that people are there drinking, possibly eating, late through the night to 7 in the morning, will be highly visible to those on the street frontage. It will be a point of attraction for those who will not have other options at that time of night, and they'll see that there's a bar operating so far as they can tell. That then leads to potential difficulties in controlling people who would like to come into the hotel, people who know about the hotel, potentially issues around being let in with key cards and so on, because this hotel is being marketed as a lean luxury hotel. Lean because they're using the minimum number of staff to keep the prices down. But the effect of that is to give rise to exactly those sorts of issues around control that have been raised in questions and which are not addressed anywhere by way of operating schedule, management plan, or otherwise. The second difficulty that this leads to is at the back for residents. There's going to be a significant problem with light pollution because people are trying to sleep late at night, and there will have to be illumination, and that needs to be in some way controlled. And I've made this mission earlier, but that is an aspect that's well within the remit of this committee in controlling nuisance by way of light pollution. And we have to look at the authority's licensing policy, which starts at page 90 of the report pack for the committee. The licensing policy makes very clear that it is expected that the guidance from the Secretary of State as to local risk assessment needs to be followed by applicants. This simply has not been done with this application. I'd look in particular, refer the committee to page 98, paragraph 13.5, and also paragraph 14.5, where the policy expects that applicants take particular care to ensure that residents are not disturbed late at night. There is a presumption, again in 14.5, that the authority will not grant the application unless satisfied that it will not create an unreasonable disturbance to local residents. The authority's policy also, and we got this at paragraphs 8.8, 8.9, 8.13, is to generally limit the hours for bars and other licensed premises to no later than midnight, and particularly that's a concern where we are close to residential premises. This application would involve necessarily a departure from that policy presumption. And so again, the authority needs to be satisfied that this won't create a nuisance to local residents. Mr. Zal's come along today and conditions have been offered. This has to, I would suggest, be in response to the material found by residents in relation to the hotel he does currently manage at the moment, which shows that there has been a significant issue with the very guests of the hotel being unable to sleep because of music and disturbance, shouting and other matters that are set out in the reviews. So this is a legitimate concern to raise. It's about the track record of the applicant and how they propose to manage this hotel. It's no good saying, oh, well, it has to be considered on its merits, this is a different site, because the business model's the same, the manager's going to be the same. So it's highly relevant to what we're discussing here today. So then we come to look at other matters, and in particular, the question of those patrons who have visited the bar, who cause disturbance to residents through coming and going, through conversations, through activities in and around the area. We know that these can only be controlled to some extent in the immediate vicinity, such as in the immediate yard, which is in the ownership of the hotel. And the borough's policy itself makes this point, which is why it starts with a presumption against granting these late night opening hours, precisely to recognise the difficulty in controlling those activities outside. We welcome the proposed control on numbers of smokers outside. We question how that is going to be enforced by the potentially only 2 members of staff. If the committee is minded to grant this application, we do request that additional conditions be imposed. Firstly, to limit the use of the rear exit after 11 p.m. To emergency evacuation only. And secondly, we would suggest that we should the committee needs to look at the wording of the conditions. 14, as it's proposed to be amended, should be changed to on the ground floor instead of the bar and restaurant area. There are references elsewhere, for instance, condition 27. Now, it's being said that this is some new concession that non-patrons that non-overnight stayers have to leave by 11. But of course, condition 27 already required that, and it wasn't going to be proposed to be amended. But the wording there is different again, because it talks about the premises, which isn't particularly clearly defined. So my submission would be that we ought to be potentially just changing the wording to the ground floor areas of the building and doing it consistently so it's clear which areas we're talking about. So to sum up, we don't accept that these matters are actually going to be controlled by condition with 40 people plus, of course, all the residents as well who are not using the bar could be coming and going throughout the night time. But in any event, if the committee were minded to grant this application, additional control is required, and that includes lighting, which is not covered by the planning permission. And I would just refer back as well, of course, to the previous decision and the planning decision as well. Even the planning decision, which at that point was only anticipating a restaurant, not a bar, proposed to limit the hours to 11 p.m. at night. The previous licensing decision likewise recognised the disturbance that would be caused, and it limited the use of the bar area, the downstairs, to 11 o'clock at night. And that's for good reason in my submission, and there's nothing that we've heard today that gives any reason to think that those decisions were wrong, and so that should be followed. Thank you.
Thank you for that. Thank you. Other objector? Which, if you could please introduce yourself. Thank you. You have up to 10 minutes. Thanks.
Hi. My name is Anaïs Lombard and I live in Victoria Gardens. I will be very brief. I appreciate the efforts that the Ruby Group is making, but I would like to say that I don't think people need music to be loud. And so I think, 40 is a start, but it's still quite a lot of people in one place. Concerning the smoking, 2 people outside, it's great, but 2 people every 5 minutes from midnight to 6 a.m., that's also a lot of people when you live 20 meters from the premises. And then I would like to finish by reading the hotel response to a complaint about noise in their hotel, in their other London hotel. Next time you stay with us, let us know in advance that you would like a quieter room. Mr. Zhu, we are resident living nearby. We cannot find a quieter room. We cannot move our houses. So we hope that you will reject this application. Thank you.
Thank you very much.
Sebastian Pearson, a Victoria Gardens resident. I live in 4 Victoria Gardens. Whilst I appreciate the recent amendments, they haven't gone far enough to protect us as residents in the immediate area. There was a reason that the license granted in the bar area was for 7 a.m. to 11 p.m. The hotel is nestled in a quiet residential neighbourhood with Victoria Gardens immediately to the rear, but Bournemouth Mews just off to the side in the alleyway and Gatehall Court right next door. 24/7 license will turn the Ruby into a potential mecca for party animals, as it does in its other hotels, and will attract foreign revellers coming to London to party at all hours of the night. This will create nuisance noise pollution, potential crime in around the immediate area, and potentially more extra work for the police force. Secondly, the double height glass, as we've discussed, for the corner area to the rear of the hotel, which looks directly onto Victoria Gardens with a 24-hour license, will provide 24/7 light pollution and illumination and further noise down to Victoria Gardens being glass, not concrete. Thirdly, the potential nuisance created by this 24/7 license will be enormous. This hotel prides itself on using all that technology has to offer, and as such has no reception, merely 1 or 2 roaming staff members with an iPad to do all the things that they need to do. Police the door, check the CCTV, is anyone around the back, noise pollution, checking who's a resident, who's not a resident, have people come with residents. You know, it's impossible to police with only a few people. There's no security guard on the door. You know, they haven't taken any of this into account. And how are they going to be able to police residents walking around to the back where they've only got 2 people in the hotel to check who's smoking and who's not, and all the noise. And the noise in the back, it needs to be appreciated. When there's tall buildings, any small amount of noise in that back area resonates tenfold to all of us residents. You know, you can always hear a pin drop because of the height of all the buildings. So, so the security guard. Fourthly, councillors do not want to create a precedent in the immediate area for Notting Hill to become a potential 24/7 drinking destination for other places. If you grant this licence, there may be others also wanting to follow suit and set a precedent. This must not be allowed to happen. Please, please do not grant a licence and protect us residents so that we can remain to live in what is a very, very quiet, immediate residential neighbourhood. Thank you.
Thank you. Councillor Smetling?
Thank you, Chair. Ladies and gentlemen, good morning. Still morning. The speakers before me have gone into much detail, and there is no need to reiterate their points. I should like to focus on the bigger picture. You have in your papers the message which Mr. Ang Ju sent to me 2 days ago, no doubt triggered by the messages I sent to Mr. Michael Struck, the Ruby Hotels Group Chief Executive and indeed founder. These are also among your documents. In it, he talks about, and I quote, the level of hostility displayed by yourself, that's me, and some of our future neighbours, even before moving into the building. All I did was point out the opposition to a relatively tall building, replacing a low-rise one with shops, and that Frogmore, the developer, had carried out consultations, and that, in short, a compromise was reached about various aspects, including the provision of some independent retail space. As it says in Frogmore's Statement of Community Involvement, paragraph 2.17, one unit would be one which the applicant hopes will attract people and help to reinvigorate this part of the high street. 2, that everywhere in RBKC, no matter how busy some streets in Kensington and Chelsea are during the day, they become very quiet at night, and that everywhere our residents live close to shops and businesses, something that actually was already said. 3, that applying for a license 3 years in advance of opening caused some head scratching and that applying for a relaxation of conditions a whole year before opening and proving good management suggested that the group did not much care about the residents' views. And it is indeed reflected now, there's uncertainty about what will happen in a year's time when, for example, a management plan was discussed. Finally, I invited Mr. Struck to review the officer's report and objections in particular and to withdraw this application for a variation of the license. Already in my objection to aspects of the license application in the June 2020 hearing, I made the point that, quote, the licensing application details have caused a considerable negative reaction from local residents, and that the response from his legal representative, that's Mr. Bayliss at the time, have only partly assuaged the concerns. Well, here we are again. I've heard the concessions, the withdrawal, reduction of demand. So, on the contrary, we could consider the actions of the applicant to be hostile to the neighbours. And why did it need a hearing, this one, for the applicant to make further reductions in their additional demands? Why not in the first place? As a reminder, the planning consent hours of operation for the A1 and A3 units are, see condition 23, Monday to Saturday, both the Class A1 retail and A3 restaurant, which apparently doesn't exist anymore, the A1 and A3 units may operate from 700 to 2300 hours. On Sundays and bank holidays, A1 use retail shall only be carried out between 8 and 10 p.m. and A3 restaurant use shall only be carried out between 8 and 2300. The current license refers to opening hours which are the same as the above hours. Conditions A8 and A9 specifically exclude alcohol consumption in the ground floor bar and restaurant, well, wherever that restaurant is now, after midnight, which is in line with the Council's midnight policy, and permitting sales of alcohol to hotel residents and their bona fide guests to be taken to their bedrooms for consumption. So why does the applicant wish to drive a coach and horses through planning consent and the current conditions with this application? Because legally they can apply to do so. Mr. Zhu claims, quote, that we do not intend for our hotel bar to be a disco or club. I don't doubt that, but if I remember rightly, the hotel does intend its public areas to be a destination for local residents, and indeed, this is emphasized in Mr. Zhu's message to me, in which he states, we intend to become an integral part of the local community as we are now with our existing hotel in Lower Marsh. He also says, quote, our neighbours often use us for birthday parties, meetings and intimate catch-ups. He says there have been no complaints from neighbours, but I have not been in touch with Lambeth Council to find out how they see it. Regardless, Lower Marsh and areas nearby are a completely different environment, as Mr. Bayliss confirmed today. I would be delighted if the hotel became an attractive new destination on Notting Hill Gate, bringing a new life to that end of the road and beyond, but not at the cost of local residents' well-being. Some nearby hotels add drinking hours. Hilton, Kensington, Holland Park Avenue, bar closes at 0200. The Laslet, Pembridge Gardens, a much smaller establishment, not 100% clear, but looking at booking times of the public areas, they end well before midnight, and I understand from one of the residents, they've actually talked to them, and it is definitely before midnight. The Hilton on Park Lane has several bars and restaurants with varying closing times, and not one of them stays open to the public around the clock. Sorry, stays open around the clock, never mind the public. The Sheraton Park Lane seems to have one bar, and that closes at 23:30 6 days a week, and 2300 on Sundays, and I submit that those hotels also cater for an international clientele, possibly much more so than the Ruby Zoe. Thus, I question Mr. Zhu's assertion that, quote, it would be grossly unfair to a hotel guest not to be able to enjoy the use of our hotel bar and the public area between midnight and the morning. For all the assurances we might get, even with the now reduced demand that all-night drinking in the downstairs bar and restaurant areas to be restricted to hotel guests only, there is no guarantee the premises will not fail to meet two of the licensing objectives, namely prevention of disorder and public nuisance. How does anyone, and this has already been covered quite extensively, I'm not sure we have a clear answer to this. How does anyone distinguish hotel residents and their guests among the potentially several dozen people? And what is to stop people making a noise on the street? I actually think this is not enforceable and not controllable, and I appeal to the subcommittee to reject this application in its entirety, and if it's minded to grant, to consider all the conditions, and also to consider special conditions for Carnival, which is a particularly difficult thing because many people, vast crowds, enter and leave the Carnival area through Notting Hill Gate. And so I'm not sure this committee is confined to just considering condition 14 in the context of this amendment, because in so I understand in section 3S or 35, subsection 4 of Licensing Act, it says one can modify any conditions. But my submission is please to reject it. Thank you very much.
Thank you very much. Any other resident? No? Thank you so much for that. So we're going to turn to questions.
Chair, could we have a short break, please? Is it possible? Sorry.
Oh, no, I think we need to do questions before we have a break, sorry, because otherwise we'll lose the momentum in terms of asking you what you've just submitted on. Thank you. William.
Thank you, Chairman. Can I really first just try and clarify a point that was just raised by Councillor Schmetterling, really looking to Mr Titcombe for advice. I mean, in the absence of any specific prohibition, such as there is on the current licence, which we are discussing today, would it be permitted for generally in a hotel for residents and their bona fide guests to drink in the bar area? Because Councillor Schmetterling suggested that this was not, some hotels, this was not going to be permitted, I mean in the early hours.
Yes, thank you, Councillor Williams. Yes, you are correct that normally hotels, there is an exemption so that hotels are allowed to have their residents and their bona fide guests to drink in the hotel 24 hours a day. This premises is restricted. The other point I would say is that this application is not a review. So, and it's not correct to say that this licence interferes with the midnight policy. It doesn't, because members of the public have to be, they're only permitted to be able to drink on the premises at midnight, at 11 o'clock. And in fact, condition 14 says that they're limited up to midnight, whereas what the applicants are doing is they're trying to bring that forward, and they're saying that they are happy for their bona fide guests, as I understand it, and also members of the public to have left by 11 o'clock, and that's also in line with the planning permission. So the question of midnight policy doesn't come into play because they already have this licence, and this is not a review, and it wouldn't be appropriate for the members to cut back the hours because this is not a review. So I just wanted to I know that hotels are slightly tricky areas, so I just wanted to make that clear.
Could
Thank you.
I just ask, where is that reflected actually in the licensing policy?
1964 Act, and then
It was the 64 Act, and converted licences were all given. So most of the existing hotels in the borough would have that facility.
So that's a grandfathered right. It's not actually something that's reflected in our current policy.
Yeah,
is that
yes,
correct?
it was grandfathered.
Yes, so it's not necessarily a precedent because it's a grandfathered right. Thank you.
Yeah, but this licence was granted. When it was granted, it was given the provision to allow residents and their hotel guests to be there 24 hours a day. That's actually on page, if you look at page...
That was in their room. And the bar at that stage was envisaged as a very small area of the
Well,
ground floor
no,
room.
it wasn't in their room. If you look at pages...
But
I just want to make this
Well,
clear.
could you actually also
Gardner,
look at the
can you
reversion
please-
as well in
Sorry,
the minutes?
Ms Gardner, can you please do the courtesy to allow the legal advisor to complete her sentences, please? Thank you.
Yeah, so if you look at pages 8 and 9 of the committee papers, where it talks about, it gives you the hours that the premises are able to operate, and it gives the opening times. So it mentions 11 o'clock for the sale of alcohol and opening times. But there's a line underneath it, and it says, the premises licence holder shall be permitted to sell alcohol on and off the premises 24 hours a day to hotel residents and their bona fide guests. So that's already a permission within this licence, which the committee doesn't have any power to remove today because it's not a review application.
So could you clarify condition 15, please?
So condition 15, I agree with what you're saying. So what 14 and 15 were doing was seeking to restrict that permission.
Yes, and indeed that's also reflected in the minutes of the hearing for the original licence, which was to room service. Thank you.
Yeah.
Any questions?
Some more questions. Yes, turning to the question of light pollution to Victoria Gardens. Now, I don't recall this being raised at the hearing which granted the licence, and which I chaired, and also, of course, because this has been explained, this is an application for variation, our ability to respond to that may be somewhat limited. Would you like to comment on that, any of the objectors?
If I might, Councillor. First of all, obviously I wasn't at that previous meeting, but this is a relevant point that has been raised in the written representations, and again, orally here, and it's a matter that we submit should be considered by this committee. In respect of the committee's powers, the jurisdiction to decide these variation applications is conferred by sections 34 and 35 of the Licensing Act 2003. Subsection 4 of section 35 states as follows. I'll read it out so that we're entirely accurate as to what it's saying. So I'll start with subsection 3. Where relevant representations are made, the authority must A. hold a hearing to consider them, unless the authority of the applicant and any person who has made representations agree the hearing is unnecessary, and B. having regard to the representations, take such of the steps mentioned in subsection 4, if any, as it considers appropriate for the promotion of the licensing objectives. And then subsection 4 says, the steps are A, to modify the conditions, plural, of the licence, so that's not limited to condition 14 that's being applied for to be varied by the applicant, and then B, to reject the whole or part of the application. And for this purpose, the conditions of the licence are modified if any of them is altered or omitted, or any new condition is added. So, with deference to, I can't remember who it was who said that you shouldn't be taking away rights that have been granted, the section specifically provides for and contemplates that additional conditions could be added to the licence, and of course what they are doing is they're cutting down or regulating the scope of what would otherwise be permitted. That's what the conditions are for.
So, yes,
Back on
please.
that, there's no dispute that the committee is not able to, or should I put it the other way, they can modify the conditions on the licence, but they can't take away, at a variation application, the licensable activities and permitted hours that they have, unless they're within the ambit of the application.
Can I also just jump in here, please? Thank you for that. That was very clear. We are aware of that. And as Ms. Titcombe said, that if we do are minded to grant any aspect of changes to condition 14, then of course we can look at adding other conditions. If we decide to completely refuse changes to condition 14, then of course it is not fair or proportionate to make any of those additional conditions regarding the exit door, regarding blackout lines, regarding anything else. So we have a balancing act to do here, and we are taking all matters into consideration. So thank you for that. I'm going to ask my question, if I may, please.
Could I just ask Councillor Williams' question about the light pollution? So if you actually turn to page 33 of the pack, that shows a purple area, and that is actually immediately, those are the Victoria Gardens premises behind. It was always understood that that was the that was the A3 use, and as a result, because the bar and the restaurant were going to close at 2300 hours, the expectation was you'd do a bit of cleaning up and then the lights would go off, and as a result, light pollution wasn't going to be an issue at the rear.
Thank you for clarifying that, yes, and thank you also, appreciate particularly Councillor Smettling's submission about the planning concerns, and again, as we've said here, licensing committee here, but if you think there are concerns in terms of planning enforcement, please do pursue that, because that is something that may be significant, and I'm afraid really is outside our remit here, but of course light pollution is within our remit, so thank you. I suppose my question is just trying to kind of contextualize everything, and as I asked the applicant how they operated, I think also my question to you is, concerns are on one complete extreme, as you have said in your submissions, you know, it could be a magnet for hen nights, and you could have 40 guests all staying there and then wanting to have a party. I complete that, I can understand that is one extreme concern. The other side of that would be a guest arriving on a late night flight, absolutely exhausted, wants to have a drink in the bar before he goes to their room, and that could be at 2 in the morning. Or it could be someone staying and going to the theatre, comes back from the theatre, just have a nightcap. So there's different variations of extremes here, and at the moment we're in a committee where we don't really know how the hotel's going to be operating. So I suppose my question to you is the worst case scenario is what you are concerned with, but do you also understand you may well be a resident in another hotel in another country and you'd be furious if you couldn't get a whiskey at 2 in the morning when you got off a long-haul delayed flight in a bar? And so I guess that's what I'm just trying to ask you.
If I may just jump in. As Dory said, I've called personally all the other hotels in the area to try to understand, you know, what people are doing, what other guests are doing in other hotels, and none of them have 24/7 bar access. Obviously, you can drink in your room, and you're welcome to do so, but I do not see why this hotel should be different. It seems that all the guests from the Hilton, from the Laslet, can leave without a bar at 3 a.m. in the morning, and so I think that as long as you're aware of it when you book the hotel, I don't think it's going to be a big deal. I don't think it's going to be a deal breaker, because most of the hotels in the area, and I'm guessing probably in a lot of places in London, they do not offer a 24/7 bar, 24-hour-7 bar.
And I'm happy to answer that as well from direct experience. I've traveled around the world and arrived at hotels late, and many hotels, probably most of them, are closed at night. If you arrive at 2 in the morning, the bar is closed. You go to your room. If you need a drink, you go to your room and you have a drink. That's kind of, you know, that's pretty normal worldwide. It's sort of, it's not a necessary remit for a hotel to have to offer. And the problem here is that it's the precedent. If you look on their website and all of their other hotels, they pride themselves on this 24/7 policy, right? And the people that then, therefore, it attracts it's a sort of clientele that therefore attracts is the problem. You know, if it was a different operator, maybe it would be a different scenario.
Chair, if I may just respond to that, to the last question as well. The answer is that the authority's got to take an appropriate view, but the aim should be to prevent the worst case type scenarios, which everyone accepts could be problematic, from occurring. The Home Office guidance, 182 guidance at paragraph 218 in relation to noise in particular says, the approach of licensing authorities and responsible authorities should be one of prevention. I just raise it because it's just immediately after at 2.20, but that's where it states that light pollution, it says measures to control light pollution will also require careful thought. So then that is in the licensing guidance, and that's why we submit it's relevant here.
Thank you, Chair. I mean, I did earlier ask Mr. Bayliss and the applicant whether, if the number of residents that could be maximum in the bar at these times could be further reduced to, say, 10, and though they did not find favour with him, I wanted to know if the residents, the objectors, had any comments on that suggestion. That's my final question.
I think, if I may, because of the specific location, you have to understand that residents of Victoria Gardens and Bulmer Mews, and I'm sure a little bit on Horbury Crescent as well, we already get a lot of disturbance at night. So we cannot just have the hotel in its own context. It has to be taken with the entire ecosystem of the Notting Hill night. And because it's a service road, we get a lot of people drinking, smoking, hanging around, playing music. So those 10 people in the hotel, it's adding to already quite a lot of disturbance. So that's my first point. So in that context, you know, 1 person or 10% at the bar, it's still an extra nuisance for us. And if we just look at it just for the hotel, at this point, I don't even understand why the hotel would want to keep the bar open. It's costly, it's one more staff. If there's 2 guests every week that want to have a drink at the bar, is it really necessary to have the bar open? Like, is it really going to bankrupt the hotel if they cannot go to the bar? I don't think so. So I'm not sure why would we go there. I'm quite puzzled by this.
Chair, could I just add, Mr. Bayliss suggested a condition about an event management plan. I've now got that condition, and it says the premises licence holder will provide a comprehensive event management plan that will include detailed policies, procedures and risk assessments to be adopted and implemented to promote the licensing objectives. The event management plan will incorporate specific plans relating to crowd management, security, health and safety risks, medical provision, noise management, waste management, traffic management, fire risk assessment, emergency planning, and a bars and alcohol plan. You could also include there light pollution.
Yeah, it sounds to me from what Heidi's reading, it's designed primarily for things like carnival, an event plan. But if you take out the words event, I'm happy to
as a management plan.
Yeah,
and that would need to be produced no later than, say, 1 month before.
Yeah.
It's okay.
Yeah, I'd be happy to accept that. Yeah.
Could I just ask, on a management plan, I mean, we've already heard that the applicant has an automatic entry phone and CCTV. Would a management plan actually expressly promote a dedicated member of staff sitting there and watching those all the time and manning them, as opposed to ostensibly looking at it from time to time?
It's a good question. Basically, that would be for the premises to assess. as to whether that requirement is necessary. And you also have to be aware that when you're attaching conditions, the cost of implementing that. So the cost for, so the committee have to be aware whether you're asking for them to incur far too much money in requiring, say, a door supervisor or someone to be specifically there just doing that role.
Thank you. I'm aware that, I know Councillor Smetling wants a break, but I'm wondering how many more questions we have. I'll come back. Applicants, do you have any questions to the objectors, please?
No questions, Chair.
Thank you. Do you have no questions? No
Could
questions?
I answer a question? Sorry, an earlier question I would like to answer, if I may, if we take a break. There.
So you're asking a question to objectors?
Yes. Answer a question.
Oh, answering, okay.
As a preliminary, I've travelled quite a lot too, into many places, and I agree with Mr. Pearson that the number of bars open at 2 in the morning is not high. Not that I seek a drink necessarily, I'd rather go to bed, but still, I agree with him. If we take the Marriott, the Sheraton, which is now Marriott chain, and the Hilton, which are amongst the most known and internationally used hotels in the world, chains in the world, in a city, London, which is also one of the most visited cities in the world. And some of them are in Park Lane, which is one of the most popular places for hotels, and they don't have bars open all night.
Thank you. I think, Councillor Smetling, you've made that clear already, but thank you very much.
Just to say, why are they, forgive me, Chair, I recounted some of the history of this to show that the residents are disturbed, and whilst planning conditions are not directly connected with licensing, the first licensing decision was partly based, I suppose, or relates to the planning conditions. Why are they coming 1 year before we even know what they're like? All these good intentions are fine. So why are they coming now, a year before, and asking for a relaxation of conditions which were granted with a lot of hassle and hair tearing and everything? Why not wait 6 months after opening or so, and then come?
Thank you, Councillor Smetling. You've already had a chance to ask that to the applicant, so I'm just trying to kind of keep to the process here, but thank you, and your point has been noted. Thank you. Yes?
I just wanted to answer your question about 10 rather than 40. If you were, for some reason, minded to grant this application, obviously, us as residents, 10 would be far preferable than 40. But as I said, I would hope that you wouldn't grant it.
Could I ask one quick question, please? I hope the committee can bear in mind there's a big difference between the summer and the winter, when people have got their windows open and we get these very hot summers, certainly in my mother's case. Under what rule can you ask people not to smoke outside? If 5 or 6 people are talking outside or chatting, and if we do find that the bar people that work in the hotel come outside, can they say, move on, go back to your room? How could you actually control that?
That comes under the management policy that Ms. Titcombe has just referred to, and I think 2 people have already been muted as the number of smokers allowed.
Yes, I understand, but if 3 appear, how would you ask the other one? What would you say? Go back to your room.
It's like any form of enforcement.
Go to your room.
Well, you say, sorry, you can't smoke quite now, you have to wait.
Because 2 people, it's very disturbing at the back, and we've had instances of it last summer, where people did congregate at the back. And I can endorse the gentleman to my right. The way noise travels in that area, bounces off the various buildings. And there were 2 or 3 kids there, and it made life hell for the residents, including for the disabled man on the top floor of Gateshill Court, who I think is older than my mum. He has no escape, and he couldn't open his window.
And a lot of that would do with also probably managing staff policy. But again, they have no control over general members of the public who are going off to Pret a Manger, getting a sandwich and having a cigarette. They're on their lunch break, workers. Yeah. They can only control
It's true, but
patrons.
Pret a Manger isn't open after midnight.
No, so the hours. Sure. And again, I just want to clarify. Can you turn your microphone for a second? I just want to clarify what we can actually look at in this committee here. We are looking at condition 14. If we are minded to refuse it in full, we cannot add any of the conditions we've talked about today regarding smoking, light pollution, exits. So just to make that very clear, if we decide to grant it in some way or modify it in some way, then perhaps we may be able to add those other conditions. So we've got this balancing act here. And so my question to you as objectors, would you prefer absolutely condition 14 not to be amended and then not have any of these other conditions regarding 2 smokers, regarding et cetera, limited numbers of people smoking and light pollution? Or would you prefer us to look at some form of amendment to count condition 14 and add on some of those other conditions?
Well, Councillor, on behalf of my client, we don't accept that is the distinction, that it's either of those options. With the greatest respect, we should...
It's not a review hearing, so I'm afraid that is the 2 options.
Well, I've addressed the committee already on what your powers are. You've got a power to accept or reject, and then you have another separate step that you can take, which is to modify the conditions. Now, whether the committee chooses to exercise that power is a different point, but I wouldn't want the committee to be misdirected as to what its powers are. Now, the second question then is, what would my clients prefer? My clients, if the committee is minded to look at this in a more narrow way, are not content with this application, because we don't consider that even with some modifications that would address the disturbance that would be caused, albeit it might reduce it compared to what it would otherwise have been. And so we would submit that the committee ought to reject the application, but if it's not with us, then it will impose such conditions as it considers appropriate, and that's the way to address it. Now, very briefly, if I might ask for the Chair's indulgence, I haven't been able to...
Sorry, I'm going to cut you off right there,
yes.
and we'll come back to you.
Okay.
So you, from your point of view, you prefer outright refusal of condition 14. I'm just trying to make it really clear for us when we go into a closed session and we can't come back and ask. And I always try to make a committee hearing as much of a dialogue as possible, because this is the chance where things can be really thrashed out. So that's your standing. So other objectors, it can literally either option A or option B, please.
Without knowing exactly what the limits of option A are, because I haven't gone through all the paperwork, it's hard for me to give an exact answer. So, I mean, it's hard for me to give an exact answer, to be honest. I don't know what I would prefer.
Can I say, I think you make it sound as if option A is 24 hours, and actually I think you do have it within your powers to grant the conditions and to grant lesser hours if you wanted to. And I don't know where other people sit. I know from my perspective, I've even looked at the geographical area, sort of, as I said, on page 33, but you've got Gate Hill Court sitting on the yellow side. So Gate Hill Court runs all the way back there with the flats. So I think it's personally the people who are immediately next to it that would have a say. I think there are major concerns about it, and I can't give you a straight answer.
No, I understand. And just to clarify, I wasn't saying completely 24 hours as kind of option A. I mean, some kind of modification to allow something could be looked at. But I understand. Okay, thank you. Any other objectors?
If I had to choose, it would just not 24 hours.
Yes, I just wanted to come back on the legal position. I've heard what you've said. But I totally agree, the committee, if they grant something, they can modify the conditions. I totally disagree with you and your interpretation that they can attach conditions if they don't grant anything. And that is the legal advice that I will be giving the committee.
Thank you for that. And when Ms. Titcombe means grant, it doesn't necessarily mean the full 24 hours. It can be any variation on that.
And I think there is a major concern still about 40. I think 10. I really think it's for Victoria Gardens and indeed for Mr. Malin's representing Gate Hill Court. But I think 10, and I think the hours, if indeed they just want to stick with the status quo. So, very tough one to call on our side.
If I might just be able to address you on the point about the licensing policy, because I'm aware that you've received advice and I haven't had an opportunity to make our submission on that. My submission is that the authority has to publish whatever its licensing policy is, has to be in that statement of policy that's published. If it operates a policy that's not published in a public domain, that is not a lawful policy. There's a case called Lumber, which establishes you can't operate a secret policy. So therefore, there's no exception in this policy for hotels, in the published policy. So the practice in this borough in the past, in respect of what it has granted for other hotels, and there is an exception for hot refreshments for hotels, but not specifically for hotel bars, for alcohol. The policy of what it's done in the past is not what its current policy is, as a matter of law, as a matter of its published statement. The presumptions in the policy I've read out, whether the committee chooses to depart from that policy is, of course, a matter for the committee.
Thank you very much for that. Thank you. I think we're reaching actually the end of the hearing, so I just want to check with our legal team and our licensing officers. Mr. Kim, shall I turn to you first? Yes.
I've got nothing further because everything was covered during the hearing.
I'm exactly the same, Chair. Thank you. Nothing further from me.
If I could possibly ask you, and you might not have the information to hand at the moment, just to clarify, but before Marks and Spencer's was there, and it was a restaurant there, their hours, do you have that?
I did look at that earlier, Chair, and unfortunately that information isn't readily available. So I would need to look into it further to be able to confirm the position prior to M&S.
Could I also add that it wasn't just solely, there were 5 shops in that parade as well, and then there was some residential flats above it. So from my recollection, the pharmacy, for example, and the Turkish one before then were early cessations because Marks and Spencer's took over the licence.
No, I'm aware the scale is quite different. I'm aware of that. And it's not hugely relevant here. I'm just trying to understand the history. But anything else, licensing officers, that have come up during the hearing?
No, nothing further, Chair. Thank you.
And governance?
No, nothing from us. Thank you, Chair.
No. Okay, well, thank you all very much for attending today. And the backwards and forwards of it, I hope you all can bear with us on this. We have to kind of try to make the right decision here. And so we're now going to retire to a closed session. And we will not be announcing a decision today. We will be announcing one within 5 working days. And so this hearing is now closed. Thank you very much.